Happy Monday! It's time for another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about unlocking cell phones. Cases that should have gone to the Supreme Court of Canada, but didn't. Lots of cell phones have very different mechanisms to unlock them. The new iPhone uses facial recognition, some cell phones use a passcode, and some cell phones use something called swipe recognition, a certain swipe pattern that unlocks the phone. This was the case for the cell phone belonging to Eric Talbot, which was seized in the course of an RCMP investigation. The RCMP applied to the court for a warrant to unlock the phone, but also for an order requiring Mr. Talbot to assist the police by giving them his swipe pattern to unlock the phone. The court granted the warrant, but they refused to grant the order requiring Mr. Talbot to assist the police in their investigation. The matter went to court, and Mr. Talbot was ultimately successful in opposing the application through all stages of court. The Crown appealed, arguing that the individuals have an obligation to assist police by providing their swipe patterns to unlock phones, and that it essentially would render police investigations impossible, if not incredibly difficult, if people weren't assisting police in this way. The Court of Appeal found that the principle against self-incrimination protected a person's swipe pattern or facial recognition or whatever feature used to unlock a phone, and ruled that Mr. Talbot was not at any stage required to assist the police in their investigation. It's a very interesting case because the Supreme Court of Canada, in declining to give leave to the issue, in some ways left the door open. Well, the law, currently as it stands, is that people don't have to assist the police in this way. By not granting leave, the Supreme Court of Canada didn't have the opportunity to say, we agree, and we think that the Court of Appeal was correct, and this does violate the principle against self-incrimination. All they really said was, we don't think that this is an issue of national importance. We don't think this is important enough for us to hear. But isn't it important enough for them to hear? As technology develops, the mechanisms used to protect the data that we keep in our smartphones become more and more exclusive. Fingerprint recognition, facial recognition, that technology gets better and better, and it's going to make it more and more difficult for police investigations to proceed as security on personal devices increases. It would have been nice for the Supreme Court of Canada to set a consistent standard across Canada that police could understand and that technology could understand so that they could work together to create a system that is effective and fair for all parties involved. And well, of course, I, as a defense lawyer, like the idea that police can't just go willy-nilly into your cell phone and compel you to participate in unlocking it. It also means that these applications can be brought in the future and that there isn't a guideline that's clear and in place across the country for lawyers to advise their clients and for Crown Counsel and police to conduct themselves by. The Supreme Court of Canada had an opportunity here to make the law clear for everybody, and instead they left a door open, if only a crack, and hopefully nothing slips through that crack in the coming years. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thanks for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. This video has been produced with the amazing assistance of Brazen Bull Creative, and I hope you subscribe, watch more, and tune in every Monday for a new episode.